let me begin. Good afternoon, everybody, and thank you for joining us today. My name is Nkosi, taking your program. The South African Bar Association hosts a speaker on a bi-weekly basis to deal with the legal topic that is intended to assist the legal practitioners and any other interested parties, both locally and internationally, with training and development, which ties in perfectly with our core values as an organization. Before we begin, some housekeeping. An appeal to the participants to ensure that your microphones and your videos are off during the address by our speaker. Should you have a question, simply just raise your hand with the icon on the Teams platform and you will be given an opportunity. A question and answer segment will commence at the end of our speaker's presentation, where we will then take your questions and engage. Kindly also ensure that your questions are strictly in line with the topic that is being discussed today. Without further ado, I'm delighted to introduce our speaker today, Ms. Noluthando Nkosi. A short bio about her before she begins. She began her career in 2009 as an intern with the then Department of Minerals and Energy, where she was placed within the Mineral Regulation Branch or Division. She developed her skills in analyzing legislative compliance by mining companies in respect of their mining rights. In 2010, she got promoted to Assistant Director, Mineral Policy, where she was introduced to drafting and amending legislation, review and development of mining policies, including working on the review of the mining charter and assisting in the drafting of the amendment bill for the MPRDA. She was also admitted as an attorney in 2010, and in 2014, she was appointed as a Deputy Director, Coordinated Legislative Drafting in the Office of the Premier for the Gauteng Province. In this role, she had the opportunity to handle different matters and sectors in legislative drafting, since the office dealt with legal frameworks from all the provincial departments. She was again promoted in 2015, where she was promoted to Director, and that is Leader of Government Business Support. This is where she provided strategic support to the Leader of Government Business in relation to matters affecting coordination and facilitation of legislative processes in the legislature and the National Council of Provinces. This was followed by a short stint with the South African Civil Aviation, where she had the role of a senior legal advisor responsible for regulation development. Currently, she is appointed as the Deputy Director, Constitutional Research and Review at the DOJ, where she is responsible for researching and developing reports on matters impacting the Constitution and its implementation. Ladies and gentlemen, I want to take this opportunity to thank our speaker and hand over the presentation, Ms. Noluthando Nkosi. Thank you.
Thank you. Good day, everybody. I'm a bit nervous, so please don't mind my voice. I'll get loud and start whispering as well. It's just nerves kicking in. So I chose my topic today, aligning legislation with the Constitution. It talks to my work experience and having worked on the process of legislative drafting, and where I'm currently now looking at constitutional matters, the implementation of, and as well as awareness of the Constitution to the public in general. So can we move on to the next slide? Oh, sorry, okay, control that, yeah. So recently the DOJ, the Department of Justice, commemorated 25 years of the Constitution being in operation, and they hosted a 3-day-long national conference to reflect on the progress made in realizing the values and aspirations informing the much acclaimed Constitution. This brought together persons from all walks of life, including the judiciary, civil society, members of parliament, academia, organs of state, as well as statutory bodies. They were engaging in robust panel discussions on the implementation, the challenges, and the successes of the Constitution. Of key interest for me was the effectiveness of the legislature in advancing constitutional democracy. One of our keynote speakers was Member of Parliament, Honorable Archibald Jomo Nyambi, who shared his lessons from Parliament over the years. And he spoke on the needs for Parliament to be well capacitated to support the implementation of its constitutional duty, and stating that it further needs to take effort in ensuring that the laws that are passed are not in conflict with the Constitution. We have long seen the legislature as being an important vehicle in ensuring democratic governance and the formulation and implementation of constitutional imperatives through passed laws. We see this being practiced in the process of drafting legislation. As people in the legal space, most of us are familiar with how the process is done. I'm just going to go through the summarized version. So we'll have a bill that goes to the relevant cabinet committee. That will be the cabinet committee responsible for the department that is drafting the bill. It could be Department of Mineral Resources or DOJ or Department of Health. So they will go to the respective to the cabinet committee, and from the cabinet committee, once they've gotten the approval, it's then released for public comments. Once comments have been received, the responsible department and the ministry will then make the necessary changes as per those public input. The draft bill is then amended as a result of the consultation process. It goes back to cabinet for approval. Once cabinet has approved it again, the bill is then submitted to Parliament. It is then sent to the state law advisors. When it's with the state law advisors, they are required to ensure that the bill is aligned with the Constitution, the law in general, and the prevailing norms and standards applicable to legislation. Once the bill is introduced, it's usually referred to the Speaker of the National Assembly, who will then refer it to the relevant portfolio committee for consideration. Where the portfolio committee then considers the bill after taking a presentation from the responsible department, and then will also ask for public comment. When the portfolio committee considers the bill, it is regarded as the best time to lobby for changes or to protest against the principles contained in the bill. And once that committee has made the changes and asked for clarity, it will then send a report on its findings to the National Assembly, as well as the bill as amended. The National Assembly considers the bill and then votes on it with the changes made by the portfolio committee. From the National Assembly, it then goes to the National Council of Provinces, where the appropriate select committee considers the bill, often in the same manner as the National Assembly's portfolio committee. Once approved by both houses of Parliament, it's sent to the President for approval and then published in the Government Gazette. This is one way of ensuring that when developing common law or customary law, it promotes the spirit, purpose, and objects of the Bill of Rights. Another is through the courts or the judiciary, and an important role they play in correcting Parliament when it errs in lawmaking. What follows is just a few cases that give the example of the role that Parliament plays in ensuring the constitutionality of our legislation. The first case refers to Gwalane versus the South African Human Rights Commission. Mr. Gwalane is a journalist who wrote an article titled "Call Me Names." The author, Mr. Gwalane, called homosexuality wrong and called for those provisions of the Constitution allowing same-sex marriages to be amended. A cartoon was accompanying the article, and it depicted a man and a goat kneeling before a priest with the captions, "When human rights meets animal rights, and I pronounce you man and goat." Obviously, the article led to a huge public outcry, and ultimately the Human Rights Commission brought an application against Mr. Gwalane in the Equality Court, alleging the article contravened Section 10.1 of the Equality Act. Mr. Kwalane brought proceedings in the High Court for an order declaring Section 10.1 read with subsection 12 and 1 of the Equality Act unconstitutional on the basis that it was inconsistent with Section 16 of the Constitution. The proceedings in the High Court and the Equality Act were consolidated. The court hearing the matter dismissed Mr. Kwalane's constitutional challenge and found the offending statements against homosexuals to amount to hate speech as envisioned in Section 10 of the Equality Act. Mr. Kwalane appealed to the Supreme Court. There he argued that the impunged provisions were overbroad and vague and did not pass constitutional muster. Subsequently, the Equality Court declared Section 10 to be inconsistent with the provisions of Section 16 of the Constitution and therefore unconstitutional and invalid. In giving judgment, the court afforded Parliament a period of 18 months to rectify or to remedy this defect. And in the interim, while that defect is being remedied, they then provided wording that needed to be replaced for Section 10.1. That's okay. I'm not going to read the new wording. It's just there for you. So this is now what is being considered for the amendments for PEPUDA, the Equality Act. Another case was Lawyers for Human Rights and another versus Minister of Home Affairs and another. This was with regards to, excuse me, for illegal foreigners who had not formally entered South Africa, but were still at ports of entry, and ports of entry being through which people could enter the South African, were airports and seaports on the one hand and border posts on the other. So Section 34 of the Immigration Act, Section 34.1, talked of an illegal foreigner might be being detained with regard and requiring a court order if it's going to be more than 30 days. But Section 34.8 did not have that provision where the person was on a ship and they were being detained for more than 30 days, but did not give them, they did not get a court order for that detention. So when the matter went before the court, the Constitutional Court, the Constitution said Section 35.2 of the Constitution applied to everyone, and the High Court was correct in finding that its protection extended to illegal foreigners. The rights of the person were therefore limited in that a suspected illegal foreigner might be detained on a ship and denied the safeguards provided for in Section 34, except that mentioned in Section 34.1a of the Immigration Act. It further held that it was of some concern that there was no obligation on the state to seek confirmation of the detention by a court order, regardless of the length of period for which the person was detained on the ship. In other words, there was no Section 34.8 equivalent to the Section 34.1d requirement that a detention went beyond 30 days had to be confirmed by a court order obtained at the instance of the state. There's no legitimate government purpose that was served by ensuring that this safeguard was not applicable to a person detained on a ship in terms of Section 34.8. To that extent, this had not been done. The limitation was not justified, and therefore this section was inconsistent with the Constitution. A third case, which judgment was recently given, was Organization Undoing Tax Abuse against the Minister of Transport. This was concerning the constitutional invalidity of the administrative adjudication of road traffic offences and the Administrative Adjudication of the Road Traffic Offences Amendment Act, which was passed by Parliament in 1998, which was to introduce the demerit system, in terms of which motorists who break traffic laws will lose certain points, and once they've lost a certain number of points, will have their driving licenses suspended or cancelled. ALTA instituted the application in the Gauteng High Court Division, and sought an order declaring that the legislation was constitutionally invalid. One of the arguments was that the legislation was invalid because on the basis that ARTO fell within the exclusive legislative competence of the provincial sphere of government, and Parliament had no competence to pass it. In giving judgment, Justice Zondo said that upheld the contentions advanced by the Minister of Transport that the subject matter of ARTO falls within the functional areas described as road traffic regulation in Part A of Schedule 4 to the Constitution, which is within the concurrent legislative competence of Parliament and the provincial legislatures. Accordingly, the Constitutional Court concluded that Parliament had the competence to pass the ARTO Act. There's, of course, more case law that assists the Parliament to ensure that the legislation is aligned with the Constitution. A third way of ensuring that legislation is aligned with the Constitution is, although indirectly, South Africa's participation and international obligations within various multilateral and bilateral treaties which have advanced constitutional democracy in South Africa. South Africa is one of 13 African member states to the United Nations Human Rights Council, and as such has the responsibility to uphold high human rights standards. In fact, this was a criteria that was demanded by all member states as to become part a part and parcel of the Human Rights Council. Being a member state to these treaties means adopting recommendations passed either by the General Assembly or recommendations stemming from peer review reports, like the Human Rights Council report of the Working Group on the Periodic Universal Review, or implementing targets set for Sustainable Development Goals. Some of those targets include adopting and strengthening sound policies and enforceable legislation for the promotion of gender equality and empowerment for all women and girls at all levels. The Universal Periodic Review is a unique process which involves a review of the human rights records of all UN member states. The UPR is a state-driven process under the auspices of the Human Rights Council, which provides the opportunity for each state to declare what actions they have taken to improve the human rights situations in their countries and to fulfill their human rights obligations. Lastly, we as the public, as citizens, play an important role in ensuring that legislation promotes the spirit, purpose, and objects of the Bill of Rights and is aligned to the Constitution. How do we do this? During the drafting process, the public is afforded 2 chances to submit comments on proposed bills, when first published by the responsible department, and again when published by the Portfolio Committee. There is no set criteria as to who can comment. If there is an interest, if you find something of interest in the bill that you have a concern about, you can make the comments and submit it to the relevant department. Although ordinary citizens may not submit bills to Parliament, they may lobby members of Parliament or committees to introduce legislation that deals with their concerns. The Constitution says a parliamentary committee meeting may not be closed to the public unless it is reasonable and justifiable to do so in an open and democratic society. Meaning, in the same way that we have the public coming in and sitting inside the courtroom to just watch what is happening in the proceedings and nobody will kick them out, the same will apply here in when you go to the parliamentary committee meetings. Unless there's a justifiable reason for that, for the meeting not to be open to the public, there's nothing stopping us public citizens from going and attending and finding out what is happening within government and the laws that are being passed. And then another one is parliamentary committees may receive petitions, representations, or submissions from public. I've often saw this petitions in the provincial legislature. The committee members will receive the petitions from the public. They will do consultations with the petitioners and take further steps depending on what is being petitioned. And if that petition leads to policy development and subsequent to a bill being developed, all the better. But this plays a crucial role in the lawmaking process. So, but this is also something that needs to be made aware to our public in general, and to promote participatory democracy, and to make the community and citizens understand that participatory democracy is not only your right to vote, but it's your right to be in the spaces where legislation is being passed, legislation that affects you, that is of that deals with your concerns. You have a right to be in those spaces and influence with the decisions that are being made. That being said, here's the opportunity to actively participate in the bill making process. These are the bills that are currently being introduced before Parliament: the Divorce Amendment Bill, the Children's Amendment Bill, the Constitution 20th Amendment Bill. There's actually even a Constitution 19th Amendment Bill that was introduced last year. Prevention of Illegal Eviction from and Unlawful Occupation of Land Amendment Bill. The last one, the Marine Oil Population Preparedness, Response and Cooperation Bill. This is to give effect to the International Convention on Oil Pollution Preparedness, Response and Cooperation of 1990. This is a clear example of South Africa's compliance with its international obligations, and also talks to complying with the Constitution as it pertains to our environmental rights. While many apartheid laws were repealed by Parliament, there are still apartheid laws that exist still today, such as the prohibition of the exhibition of films on Sundays and public holidays, and the Witchcraft Suppression Act of 1957. This is the legislative reform process. But now, because the process of passing legislation is long and time-consuming, due to the fact that legislation has far-reaching implications for citizens of South Africa and even beyond its borders, the process is the legislative reform process is not something that we're going to be seeing very soon. But however, there is work being done as we speak by the Law Reform Commission through research, studying and investigation, and making of recommendations for the development, improvement and modernization of law, and including the repeal of absolute and unnecessary provisions. As currently the Witchcraft and Suppression Act of 3 of 1957 has a discussion document that's out for comment, which will close on the 31st of August. I would encourage the public and in large to visit their website, look at what documents they have for public comment, and participate. Have your say in how a legislation is made, and ensuring that the legislation that is passed addresses your concerns, but also is aligning itself with the Constitution and promotes the spirit of the Bill of Rights. Thank you. I think that's the end of my presentation. Thank you.
Thank you so much, Noluthando, for that informative session. I'm not sure if you're able to hear me, see me, at least hear me.
Yes, I can. I can see you and hear you.
Okay, great. I'm just looking through the chat box and I see we don't have any questions. If anybody has a question, this is your opportunity to either raise your hand or just jump on the platform and ask your question. But in the meantime, I have a question for you, Ms. Nkosi. I heard you mention participatory democracy. And I just want to get a feel or your opinion in terms of its effectiveness. Do you feel that it is effective at ensuring that the lobbying truly gets to reach everybody that it is intended to reach? And what examples exist, or how do you prove that you have reached, the democratic intent on reaching? And if that is not the case, what steps can be taken or have been taken to ensure that that is the case? I hope I'm clear enough in my question.
Okay.
Thank you. You are muted.
Sorry about that. As I was saying, so in the Department of Justice, we do have a unit that's responsible for participatory democracy. That includes going out to the public, to communities, and explaining to them the rights that they have as outlined in the Constitution and how they can exercise those rights. The most recent engagement was last week Friday, where there was a engagement with the youth and the right to vote, and looking at the concerns of the youth and why they would not want to vote or why they want to vote with the forthcoming elections. That is one way of the participatory democracy. Another way is in the different areas, residential areas that we live in, with our ward councillors, or you are able to reach your ward councillor as the constituent of the respective parties, and engage with them on issues that you feel need to be addressed, either in the municipal level, at provincial level, which would be your legislature, or at parliament level through the members of parliament. As I also mentioned, you have the option of submitting petitions to portfolio committees at parliament level as well as provincial legislature. So there's various ways of doing that. I'm not sure if there's a specific way you can report it you can have evidence of that. Besides, if it's a written submission, that is how you can do it. The engagements that we have with communities are recorded. We have reports on the engagements that we have and the outcomes of that. And in those engagements, we usually, depending on the topic that is being discussed, we usually invite experts in the different fields to come and give they not just their expertise, but what is being experienced on the ground, so that we then go take it back to our principals and find it, if it can find a way into legislation, even better. I hope that answers your question.
Thank you, Noluthando. Absolutely, very clear. We have a question in the chat box, and the question is, what is the difference between the white and the green paper? Did you get that?
Yes, I did. Just hold on for me, please.
Yeah.
So the green paper is a document that presents policy proposals for the public consultation. Once that is being once the consultation has been done and received public comments, it then is followed by the white paper, which is the official proposal that will be submitted to cabinet to start the vehicle of developing legislation. Any further questions?
Thank you. No, thank you. Yes, yes. There's another question from Bar. The question is, how often does the LRC meet? That's the Law Reform Commission.
Meet in terms of?
He didn't quite indicate. Council, are you able to expand on your question for clarity?
Good afternoon, Noluthando. I hope you can hear me.
Afternoon, I can hear you.
Yeah, so the Law Reform Commission has been, I would probably, you can correct me if I'm wrong, suspect that they would work hand in glove with all the other entities dealing with lawmaking. And I'm just curious to know when and how they meet, and if they meet, what sort of involvement or the extent to which their involvement eventually translate into their recommendations being elevated into some form of a legal basis for that, for the, and I'm not articulating myself entirely appropriately, but I'm not sure whether you get my drift.
So are you asking, is the engagement with the public or with departments in terms of the process of introducing legislation?
Both.
Both.
Yes.
Okay. Is it advocate?
Just call me Bart.
Okay, Bart. Sorry. So my involvement with the Law Reform Commission is very limited. What I'm going to respond to is based off what is on the website. We are not in the same office. My engagement in my current position is with them is very limited. So their role is they can introduce documents to the relevant departments. I'm going to go back to the example of the Witchcraft Suppression Act. They could then go to the department responsible for that after they've done a study on the act and the proposals on amending it, and approach the department to introduce legislation to repeal that act, or repeal it in its entirety or certain provisions of that act. Thereafter, then they will go out to the public and call for comments when the discussion document is ready to be shared with the public for comments. As to what happens after that, unfortunately, I cannot speak on their behalf on that. I would advise that maybe you can contact their office, or they're going to their website to get further detail.
Yes, I think perhaps a little follow-up to that. For instance, I think the last time when I studied one of the reports, the Law Reform Commission had, for instance, proposed that prescription be extended by 5 years. Ordinarily the prescription period would apply to a debt and would then prescribe within a period of 3 years. So I was quite curious to see how that would be then eventually translated in amendment to the Prescription Act.
Okay, I don't want us to engage, but let me just do something quickly. I'm going to go onto the Parliament website and find out if they do have a bill that talks to that. The bills that I mentioned are bills that were recently introduced, as in during the course of this year, and some late last year. So you might find it had already gotten to the point of being a bill and is before Parliament, but it might be already with a portfolio committee.
Thank you.
Just bear with me quickly.
I see we have a hand
Okay, I will take another question in the interim.
Sure. It seems Dumisa has his hand up, or her hand up.
Yes.
You can unmute yourself, Dumisa, and go ahead.
Thank you, Council. Good afternoon. What I want to check from Noluthando is the question of the manner of consultation when it comes to these bills. Why I'm asking that? For example, if you reading the first one, which is witchcraft suppression, vis-a-vis the prohibition of exhibition of films, the targets there are different. We might be saying that we are actually focusing to the general public, but obviously the target is different. How do we make sure that we've actually consulted fully in terms of the people in respect of the actual act which is directed to? If I can make an example, witchcraft is practiced down there at the rural areas. That's my understanding. And the people who are responsible there are the chiefs and the people who are there who are not accessible to this kind of communication that we have. But if you're going to focus in terms of the prohibition of exhibition of films, those people already are on communication channels. They are able to contribute whatever that they want to contribute towards the bill. How to make sure that we actually reach? In fact, this question, it relates to the question which was raised by our facilitator. And I'm of the opinion that maybe I did not get it the full response. How do we make sure? Because you find that there will be a new law which is actually introduced, and then you hear from the general public, I think everybody's aware of that we don't know anything about this law. We wouldn't have approved this law or even contributed positively towards this law. So how do we make sure that ever since as we're going forward, we've picked up those problems, but how do we make sure that we address those problems to limit these questions of complaints from the general public?
So, Dumisa, during the drafting process, that is when it's still with the department before it goes to portfolio committees. Part of the consultation is with stakeholders. That means going to different communities. So there'll be somebody who will be responsible for identifying communities where if there's an issue that has been persistent, like the witchcraft, when you're saying, you know, most of us see it as a place in the rural areas. There will be imbizo that will be held with those communities, and from those engagements, they will try to understand what the issues are, how do they identify what witchcraft is, and so for them to do those engagements, they go and sit with the chiefs or the traditional leaders of those communities. In most instances, for them to identify the traditional leaders, it's with engaging with the Department of Traditional Affairs and Local Government and the municipalities as well. So there's different stakeholders who play key important roles in identifying the communities that are most impacted by the policies that are being developed. And then the department then will go and have engagements with those communities face to face. And in most instances, the idea is to make sure that they engage with them in a language that they understand. So if we say go down to Limpopo and majority of the community that will be in attendance is Pedi speaking, we will find somebody within the department who can translate the English into Pedi, and they speak in a language that they all understand. We can comprehend what is being proposed by government, and then government also understands what the needs of the community are, so that when they then sit down and do a rough draft, those are things that have been taken into account. So, but now the general public is not always going to know about those imbizos. It will depend on how it's advertised, because the engagements is through the different channels of government to the traditional leaders. It's not always going to be broadcast to say we are going to this village and we're going to go discuss that. And so it's only that community that will be made aware that a certain department is coming to see them, and this is what is going to be discussed. So the consultation process is not just that we published for comment and that's it. Before we even take it to that point, before it gets to that point, there's already actual one-on-one engagement with the community that is most affected by the policies that are being developed. I hope that answers your question.
Thanks, Noluthando. Understood. Thank you so much.
Noluthando, another question from me as a follow-up to what I had initially asked. I heard you mention the advertising aspect of it, and please correct me if I'm wrong. Does the department ever utilize traditional media to advertise in instances where the general public is concerned? Your typical, your radio, your newspaper, to invite participation? Or is that something that the department does not, an area that isn't often utilized? Is it, because from what I'm hearing from you is a lot of it has a lot to do with on ground physical engagement with the various stakeholders and communities. Do you ever, or does the department ever utilize traditional media? Thank you.
Okay, actually the department does that very often, depending on different radio stations. Today there was we had an interview on Mafikeng FM on the topic was on the services that are offered by the master's office. So you'll find each week, or maybe alternative weeks, will have officials going to radio stations to talk on certain topics. During Child Protection Week, we'll have people from our not court services who deal with the Children's Act and childcare, going to radio stations to talk on pertinent issues. And most of sometimes it's not always your commercial radio stations, but like your Mafikeng FM, it's radio stations where we're able to convey the message even into the rural areas. Because your commercial radio stations will not necessarily have the same reach, a far reach that will go into the rural areas. Like for now, like for example, I'm from Nelspruit. When I drive down to Nelspruit, I cannot access Kaya FM unless I'm accessing it online. But when I put on the radio station and I get into Mpumalanga province, there won't be a reception for that radio station. So we do go out to traditional media, but not necessarily just commercial radio stations, but every radio station that will have a reach to communities. Thank you.
Thank you so much for that. It doesn't seem like there are any questions in the chat box. Let me verify. Okay. Any more questions?
I
suppose we can use, okay, there's a hand.
Sorry, I just wanted to get back to Bart.
Okay, someone has a hand.
Oh, sorry, no, so sorry. Just to get back to Bart, there is, he can just go visit the website from the Law Reform Commission. I believe that was still a discussion paper because it hasn't been, I'm not seeing it on the Parliament website, the topic on the extending prescription. So he can just check on their website and look at the reports that they have on the Law Reform Commission's reports to see how far they went with that matter.
Thank you. I'm sure Bart got that. There was a hand from RSA Bar.
Thank you very much, Olivering. And Noluthando, just one quick question, just for clarity purposes. I want to check. South Africa is part of is a member state to the International Criminal Court, and that was through the Rome State. So I wanted to check, before that particular legislation was signed to be binding on the Republic, did it go through the same constitutional process as you're explaining?
No, can I just get clarity? Are you saying that there was there's legislation stemming from the criminal court,
I'm saying,
International Criminal Court?
yeah, yes, the Rome Statute is the one that binds us to be member state of the International Criminal Court. So
Yes.
I wanted to understand whether was that legislation, before it was accepted to be binding on the Republic, did it go through the department, consultations with the public and so forth, or did it directly go to Parliament, then it was accepted to be binding on the Republic?
Okay, so what happens with international obligations and treaties, before we become signatories to those treaties, DECO, in working with the responsible department, in this case with Department of Justice, they will then seek a permission from Cabinet to be signatories to that convention. And in seeking that permission, they will outline what will be required from him and the development of legislation. So once we get that permission from Cabinet to become signatories to international treaties and the implications thereof, the legislation that follows, that stems from those international treaties, then follows the same process. Because it's an international because it stems from an international treaty, it does not skip the usual process of legislative drafting. It still goes through going to getting approval from Cabinet first, going for consultation, the imbizos, going to the State Law Advisor's Office to be certified that it's in line with the Constitution, and then going back to and then being introduced to Parliament. It still goes through that rigorous process. The only difference is, before we sign, we must still get Cabinet approval to say we can be signatories to such and such a treaty.
Thank you very much.
Noluthando, it seems this brings us to the end of our session. There are no more questions, no more hands raised. And any parting words, or are you happy for me to conclude the session?
Thank you for the opportunity. I felt like I rushed through the presentation, nerves get the better of me, but this was also a learning curve for me. The questions were unexpected, but that is part and parcel of the presentations. But thank you for having me. Hopefully I hope to join you again another time. Not too soon though. Thank you.
You did incredibly well. Your topic was phenomenal and quite informative. And thank you for making time. And I want to thank our participants as well for logging in and being a part of our session. And as you know, we hold these sessions on a bi-weekly basis. So please do join us. Do check our LinkedIn. We post every other week. And you will always find the link to the next session, the speaker, and the topic. And with that, I close our session for today. Thank you and have a good afternoon.
Bye.
Thank you.